I never expected to get an HOA fine for a pile of snow on my own property, but that's exactly what happened on a freezing January morning in Boulder, Colorado. The certified letter arrived on a Tuesday, and when I opened it, my coffee nearly sprayed across my kitchen table. My name is Patrick Daniels, and I've lived in the Meadowbrook Heights development for 3 years. It's one of those cookie-cutter neighborhoods where every house looks vaguely similar, with strict rules about everything from mailbox colors to lawn ornament sizes. I'd managed to avoid HOA drama until the winter of 2025 decided to dump record-breaking snowfall on our little slice of suburban Colorado. The fine was for $250. The violation: an unauthorized snow pile exceeding the maximum allowable height of 4 feet on residential property. I read the letter 3 times, convinced it had to be some kind of joke. Who on earth measures snow piles? And since when was there a height restriction on snow that I cleared from my own driveway? I grabbed my jacket and boots and trudged outside to look at the offending pile. It sat at the edge of my property line, right where my driveway met the grass. After the blizzard 2 weeks ago, I'd spent hours with my snowblower clearing a path for my truck. The snow had to go somewhere, so I'd piled it up like every other homeowner on my street. Sure, it was tall, maybe 6 or 7 feet at its peak, but it was January in Colorado. What did they expect? My neighbor, Tom, was outside scraping ice off his windshield. I called over to him. "Hey, did you get one of these HOA letters?" He looked up, squinting against the morning sun reflecting off the snow. "About what?" "About snow pile height. Apparently mine's too tall." Tom laughed. "You're kidding." "No, I didn't get anything, but my pile's maybe 3 feet max. I've been shoveling mine into the backyard." I looked down the street. Most of the other homes had smaller snow accumulations, or they distributed it across their lawns. Mine stood out like a miniature mountain, glittering in the sunlight, but it was on my property, well within my lot lines. I'd been careful about that. Back inside, I called the HOA management office. A chipper voice answered. "Meadowbrook Heights HOA, this is Brenda speaking." "Hi, Brenda. This is Patrick Daniels from 342 Birch Lane. I just received a fine for snow pile height, and I need to understand what regulation I'm supposedly violating." "Oh yes, Mr. Daniels. Let me pull up your file." I heard keyboard clicking. "Yes, our board president, Carol Patterson, conducted an inspection on January 15th and noted your snow accumulation exceeded the maximum height restriction outlined in Section 12 of the Community Guidelines." I've never heard of Section 12. And I read the HOA guidelines when I bought the house. It was added during last month's emergency board meeting. All residents were notified via email. I pulled up my email on my phone, scrolling back through December. I don't see any notification. It was sent to the email address on file. Let me verify. Is it patrickdaniels.82@gmail.com? No, it's patrickdaniels@gmail.com. No numbers. There was a pause. "Oh, it appears we have an incorrect email address in our system. So you're fining me for violating a rule I was never properly notified about." "The rule was still properly enacted, Mr. Daniels. Lack of notification doesn't invalidate the violation." I took a deep breath, counting to 5. "Can I appeal this fine?" "You can submit a written appeal to be reviewed at the next board meeting. That's scheduled for February 10th. That's 3 weeks away. The fine says I have to pay within 10 days or face additional penalties. You can pay now and receive a refund if your appeal is successful, or I can fight it and potentially owe more if I lose." "That's correct." I thanked her and hung up, already feeling my blood pressure rising. This was exactly the kind of bureaucratic nonsense I'd heard about HOAs but hoped to avoid. I opened my laptop and started drafting an appeal letter, documenting everything: the lack of proper notification, the questionable timing of the rule change, and most importantly, the fact that my snow pile was entirely on my property and posed no safety hazard to anyone. 2 days later, I got a response. Not from Brenda, but from Carol Patterson herself. She called my cell phone at 7 in the morning. "Mr. Daniels, this is Carol Patterson, president of the Meadowbrook Heights HOA. I understand you filed an appeal regarding your snow pile violation." "That's right. I don't believe the fine is valid." "The fine is absolutely valid, Mr. Daniels. The rule was properly enacted by a majority vote of the board, and all residents are responsible for staying informed about community guidelines." "I wasn't notified." "Your office had the wrong email address." "That's an administrative error, not a legal defense. But that's not why I'm calling. I'm calling because your snow pile remains in violation, and every day it stays above 4 feet. You're accruing additional fines of $50 per day." My hand tightened on the phone. "You've got to be kidding me." "I don't kid about community standards, Mr. Daniels. Meadowbrook Heights is a premier neighborhood, and we maintain that status through rigorous enforcement of our guidelines. Your snow pile is an eyesore and a violation. I expect you to remediate it immediately. It's snow. It'll melt. The weather forecast shows temperatures staying below freezing for at least 2 more weeks. That pile could be there until March. Unacceptable." "It's on my property, Carol. I can pile snow wherever I want on my own land." "Not in this community, you can't. Read your HOA agreement. By purchasing a home in Meadowbrook Heights, you agreed to abide by all current and future guidelines established by the board. Future guidelines that I'm never told about. The email issue will be corrected, but the fine stands. Remove the snow pile to below 4 feet or continue accruing daily penalties. Your choice." She hung up before I could respond. I stood in my kitchen, staring at my phone, wondering if this was really happening. I'd heard horror stories about HOAs, but this seemed excessive even by those standards. I spent my lunch break researching Colorado HOA laws. The statutes were dense and confusing, full of legal jargon that made my head spin. From what I could understand, HOAs had broad authority to create and enforce rules, but they had to follow proper procedures. Notification requirements varied, but most sources suggested that residents should receive reasonable notice of rule changes, especially those that could result in fines. That evening, I drove to the Boulder County Recorder's office before it closed. I requested a copy of my property survey, the official document that showed exactly where my property lines were. The clerk printed it out for $20, and I studied it in my truck under the dome light. My lot lines were clearly marked, and when I compared them to my mental map of where the snow pile sat, I was confident it was entirely on my land, at least 3 feet from the property line. The next morning, I took measurements. I used a tape measure and some stakes to mark out the exact boundaries shown on the survey. The snow pile was definitely on my property, not even close to the edge. I took photos from multiple angles, including shots that showed the survey stakes and the measurements. Armed with this evidence, I updated my appeal letter and emailed it to the HOA office, copying Carol Patterson directly. I outlined my case: improper notification, questionable rule validity, and most importantly, the fact that the snow was entirely on my private property and presented no danger or obstruction to common areas or neighboring lots. Carol's response came within an hour. It was terse. "Your appeal is noted and will be reviewed at the February board meeting. In the meantime, the daily fines continue to accrue. You are now at $400 in total penalties. I called a lawyer that afternoon. His name was Steve Richardson, and he specialized in real estate and HOA disputes. His consultation fee was $200, which seemed ironic given that it matched my original fine. Steve listened to my story, reviewed the documents I'd scanned and emailed him, and gave me his assessment. They're on shaky ground with the notification issue, but HOAs have a lot of leeway in Colorado. The bigger problem is the daily fines. Those can spiral out of control fast. I've seen HOAs put liens on properties for unpaid fines. Can they really do that over a snow pile? If it's a violation of community guidelines that were properly enacted, yes. The question is whether these guidelines were properly enacted. You said there was an emergency board meeting. That's what Brenda told me. Emergency meetings are allowed, but they have to meet certain criteria. The issue has to be truly urgent. I'm not sure how a snow pile height restriction qualifies as an emergency. So what do I do? You have a few options. 1. You can comply and remove the snow pile, then fight the fines you've already incurred. 2. You can refuse to comply and escalate this to litigation. 3. You can try to negotiate with the HOA. What would you do? Steve was quiet for a moment. Honestly, I'd probably just spread the snow out and make the problem go away, but I understand if you don't want to give in on principle. These HOA power trips are real, and sometimes people need to push back. I thanked him and hung up, no clearer on what to do. Spreading the snow would take hours of work, and the ground underneath was frozen solid. Plus, my backyard was small, and I didn't have much space to redistribute 7 feet of compacted snow. But more than that, it bothered me that Carol Patterson thought she could bully me into compliance over something this petty. That weekend, I got a visit from Carol herself. She pulled up in a white Lexus SUV, climbed out wearing a puffy designer jacket, and marched right up to my front door. I saw her through the window and considered not answering, but I figured I might as well hear what she had to say. I opened the door before she could knock. "Carol, what can I do for you?" She was in her early 50s, with blonde hair styled in that soccer mom way that probably cost a fortune to maintain. Her expression was stern, lips pressed into a thin line. "Mr. Daniels, I wanted to speak with you in person since our phone conversation didn't seem to make an impression." "It made an impression. I just disagree with your position. This isn't a matter of agreement or disagreement. It's a matter of compliance. You signed an HOA agreement. You're bound by it." "I'm bound by reasonable rules that are properly communicated. This doesn't qualify." She glanced past me toward the snow pile, visible from my front door. "That monstrosity is unacceptable. It's visible from the street. It lowers property values. It makes our entire neighborhood look unkempt." It's snow. In January. In Colorado. It's excessive snow piled to an unreasonable height. Other residents have managed to clear their driveways without creating miniature ski slopes. Other residents have bigger yards or different property layouts. I worked with what I have. Carol's expression hardened. "You're now at $600 in fines, Mr. Daniels. That will be $900 by Monday. When it reaches $1,000, we can initiate lien proceedings. Is your pride really worth that?" "This isn't about pride. It's about property rights. That snow is on my land, not yours or the HOA's. Your land is subject to community standards. You gave up unlimited property rights when you bought here. I didn't give up reasonable use of my own property." We stared at each other for a long moment. Finally, Carol said, "I came here hoping we could resolve this amicably. I see that's not going to happen. You'll be hearing from our attorney." She turned and walked back to her Lexus, her boots crunching in the snow. I watched her drive away, feeling both vindicated and anxious. An HOA attorney meant this was escalating fast. Sunday evening, I got a call from my neighbor across the street, a retired teacher named Alice. "Patrick, I hope you don't mind me calling. Tom gave me your number." "No problem, Alice. What's up?" "I heard about your situation with Carol and the HOA. I wanted you to know that I think what she's doing is ridiculous. Several of us think so. I appreciate that. But I also wanted to warn you, Carol can be vindictive. Last year, she went after the Hendersons for painting their trim the wrong shade of gray. She made their lives miserable for months. Eventually, they just sold their house and moved. Seriously, she runs this HOA like her personal fiefdom. Most people just go along to avoid the hassle. But some of us are getting tired of it. Have you considered running for the board?" Alice laughed. "I'm 72 years old. I don't have the energy for that battle, but you're young. You could fight this." After we hung up, I thought about Alice's words. I didn't want to become known as the neighborhood troublemaker, but I also didn't want to roll over for someone who was clearly abusing their authority. Monday morning, I called Steve Richardson again. The HOA president came to my house. She threatened me with a lien. What are my options? Did she put that threat in writing? No, it was verbal. Okay, here's what I recommend. We need to get ahead of this before they actually file a lien. I'll draft a cease and desist letter citing the improper notification and questioning the validity of the emergency board meeting. We'll also request all documentation related to that meeting, minutes, attendance records, the works. If they can't produce proper documentation, their rule change might be invalid. How much will this cost? My retainer for HOA cases is $2,000. That covers initial filings and correspondence. If this goes to court, we're looking at significantly more. $2,000 to fight a $250 fine that had now ballooned to over $600. The math was insane, but I thought about the Hendersons selling their house, about Carol Patterson bullying people with impunity. Sometimes principles cost money. "Do it," I said. Steve got to work immediately. By Tuesday afternoon, he'd sent a formal letter to the HOA's management company and to Carol Patterson directly. He also filed a request with Boulder County to review the HOA's corporate filings and meeting minutes, which were technically public records since HOAs were incorporated entities. Wednesday, I got a call from an unknown number. It was a man named Gerald Simpson, attorney for the Meadowbrook Heights HOA. "Mr. Daniels, I've reviewed your attorney's letter. I'm calling to see if we can resolve this matter without further legal action." "I'm listening." "The HOA is willing to reduce your fine to the original $250 and waive the daily penalties, provided you bring your snow pile into compliance within 72 hours. That's not a resolution. That's capitulation. What about the improper notification? What about the questionable emergency meeting? The board followed proper procedures in enacting the snow height restriction. The notification issue is regrettable, but doesn't invalidate the rule. As for the emergency meeting, Colorado HOA statutes allow boards to convene emergency sessions when circumstances require immediate action. What was the emergency? Snow falls in Colorado every winter. The board determined that excessive snow accumulation created potential liability issues for the community. That's absurd. Snow on private property doesn't create HOA liability. Gerald's tone remained professional but firm. "Mr. Daniels, I've been practicing HOA law for 15 years. Boards have wide discretion in determining what constitutes community standards and safety issues. You can fight this, but it will cost you far more in legal fees than simply complying. Maybe, Or maybe your board president is on a power trip and needs to be checked. I'll convey your position to my client, but I'm advising you that continued non-compliance will result in accelerated enforcement actions. After he hung up, I called Steve and relayed the conversation. He said, "They're trying to pressure you into compliance before we can dig into their documentation. That actually makes me think we might have a good case. If everything was proper, they'd just steamroll forward. The fact that they're offering a deal suggests they're worried." So what's our next move? We wait for the document production. They have to respond to our request within 10 business days. Let's see what they give us. Those 10 days felt like forever. Every morning I looked out at my snow pile, still standing tall and defiant. The weather stayed cold, so it wasn't melting. If anything, it had gotten more compacted and icy, even harder to remove now than when this whole thing started. I got dirty looks from some neighbors when I checked my mail. One guy I barely knew, Rick from 3 houses down, actually stopped his car to yell at me. "Just remove the damn snow. You're making the whole neighborhood look bad." I didn't respond, just walked back inside. It was interesting how quickly people turned on you when you went against the status quo. Even when the status quo was unreasonable. On day 9, Steve called. "I got the documents from the HOA. Patrick, this is interesting." Good interesting or bad interesting? Potentially very good. The emergency meeting minutes show only 3 board members present. According to the HOA bylaws, they need a quorum of 4 for official votes, and the meeting notice was only sent 24 hours in advance. Colorado law requires 48 hours for emergency meetings. So the rule change wasn't valid. It might not be. I need to verify some details, but this could invalidate everything. The original fines, the daily penalties, all of it. What happens now? I'm going to file a formal challenge with Boulder County and demand the HOA rescind the rule and all associated penalties. If they refuse, we go to court. How likely are they to just rescind it? Depends on how stubborn they are, and how much they want to avoid a legal battle that could expose other procedural problems. Steve filed the challenge that afternoon. The HOA's response came faster than expected, delivered by Gerald Simpson in a terse email. The board stands by its actions and will vigorously defend its authority to enact community standards. We were going to court. The hearing was scheduled for mid-February in Boulder County District Court. Steve prepared meticulously, gathering not just the HOA documents, but also statements from neighbors, property surveys, and photos of snow piles throughout the neighborhood that hadn't been cited for violations. That last part was particularly interesting. Steve drove through Meadowbrook Heights with a camera, documenting snow accumulation at every property. While most were smaller than mine, at least 4 other homes had piles that appeared to exceed 4 feet. None of them had received fines. Selective enforcement, Steve explained. If they're only targeting you while ignoring similar violations elsewhere, that's a problem for them. The day before the hearing, Carol Patterson made one last attempt to intimidate me. She showed up at my house again, this time with another woman I didn't recognize. "Mr. Daniels, this is Jennifer Walsh from the HOA board. We're here with a final offer." Jennifer was younger than Carol, maybe early 40s, with dark hair and a nervous energy. She spoke quickly. "We're willing to dismiss all fines and penalties if you'll agree to reduce your snow pile to compliant height and sign a stipulation agreeing not to pursue legal action against the HOA." "Why would I agree to that? We're going to court tomorrow." Carol's expression was icy. "Because if you lose, you'll owe attorney fees on top of all the fines. You could be looking at $10,000 or more. And if I win, you'll owe my attorney fees. That's not guaranteed. The judge has discretion. I'll take my chances. Jennifer tried a softer approach. Mr. Daniels, Patrick, this has gotten out of hand. Nobody wants to spend the time and money on a court battle over a snow pile. Can't we just resolve this like neighbors? That ship sailed when Carol started threatening me with liens. Carol stepped closer. You think you're making a point? All you're doing is making enemies. People in this neighborhood will remember this. They'll remember that you put your ego ahead of the community. I'll remember that the HOA abused its power and targeted me for something that wasn't even a rule when I piled the snow. That's what I'll remember. They left without another word. That evening, I could barely sleep. Part of me wondered if I was being foolish, spending thousands of dollars on principle. But another part knew that if I backed down now, people like Carol would keep running roughshod over reasonable homeowners who just wanted to live their lives. The hearing was at 9 in the morning. The courtroom was smaller than I expected, more like a conference room with a judge's bench. Steve and I sat at one table, Gerald Simpson and Carol Patterson at the other. The judge was a woman in her 60s named Barbara Winters. Judge Winters reviewed the filings quickly, then looked up. This is about a snow pile. Yes, Your Honor, Steve began. My client was fined by his HOA for a snow pile on his private property that allegedly violated a height restriction. However, the restriction was enacted at an improperly convened emergency meeting with insufficient notice and without a proper quorum. Gerald stood. Your Honor, the HOA followed all applicable procedures. The emergency meeting was properly noticed to available board members, and 3 members constitute a quorum under exigent circumstances. The bylaws explicitly require 4 members for a quorum, Steve countered. There are no provisions for reducing that requirement. Judge Winters held up a hand. I've read the bylaws. Mr. Simpson, where does it say 3 members can constitute a quorum? In emergency situations where immediate action is required and a full quorum cannot be assembled, Your Honor, Colorado statute allows for a reduced quorum. Show me the statute. There was a pause while Gerald shuffled through his papers. He cited a section number, and Judge Winters pulled it up on her computer. After a moment, she shook her head. That statute applies to emergency actions to protect health and safety, such as immediate repairs to common areas. I don't see how it applies to enacting a new restriction on snow pile height. The board determined that excessive snow accumulation posed a safety risk, Your Honor. On private property, how? Gerald seemed to struggle for an answer. Potential collapse, visual obstruction, aesthetic degradation of community standards. Was there any evidence presented at this emergency meeting of actual safety concerns? Engineering reports, incident reports? The board relied on its collective judgment. Judge Winters turned to Carol. Miss Patterson, you're the board president. Can you explain what emergency necessitated this meeting and rule change? Carol stood, smoothing her jacket. Your Honor, we'd received complaints from multiple residents about unsightly snow piles. We needed to address the issue before it became a larger problem. Complaints about aesthetics constitute an emergency. In a community that prides itself on maintaining high standards, yes. Judge Winters didn't look convinced. Mr. Richardson, what's your client seeking? Steve stood. Dismissal of all fines and penalties. A declaration that the snow height restriction is invalid. And attorney fees. Mr. Simpson, does the HOA have any evidence that Mr. Daniels' snow pile posed an actual danger or violated any restriction that was in effect at the time he created it? The pile is on his property but visible from common areas and affects the community's appearance. That's not what I asked. Was there any restriction on snow pile height before this emergency meeting? No, Your Honor, but the HOA has the authority to enact new restrictions as situations arise. Through proper procedures, which brings us back to the quorum issue. Judge Winters flipped through more documents. I'm also concerned about the notification problem. Mr. Daniels never received notice of the rule change. That was an administrative error, Gerald said. It doesn't invalidate the rule. It does if proper notice is required under your own bylaws. And according to what I'm reading, rule changes must be communicated to all residents in writing at least 5 business days before taking effect. Emergency rules can take immediate effect, Your Honor. But they still require notice. Otherwise, how is anyone supposed to know about them? Gerald had no good answer for that. Judge Winters sat back in her chair, thinking. Finally, she said, here's my ruling. The emergency meeting did not meet the procedural requirements for enacting a valid rule change. The notice was insufficient, the quorum was inadequate, and the alleged emergency doesn't meet the statutory definition. Therefore, the snow height restriction is invalid and all fines and penalties are dismissed. I felt relief wash over me. Steve squeezed my shoulder. Judge Winters wasn't done. Furthermore, I'm troubled by the selective enforcement issue. Mr. Richardson has documented several other properties with similar snow accumulation that weren't cited. Miss Patterson, this appears to be targeted harassment rather than good faith enforcement of community standards. Carol's face flushed red. That's not true, Your Honor. We've been conducting ongoing inspections. After Mr. Daniels challenged his fine, that's convenient timing. Judge Winters looked at me. Mr. Daniels, do you want to pursue your request for attorney fees? I glanced at Steve. He whispered, it's your call. I thought about it. The attorney fees would hurt the HOA's budget, which ultimately came from all the homeowners, including me. No, Your Honor, I just wanted the invalid fine removed. Very well. The fines are dismissed. The HOA is ordered to correct their board procedures and ensure proper notice for any future rule changes. This matter is concluded. We stood as Judge Winters left the courtroom. Carol wouldn't even look at me. She grabbed her purse and stormed out, Gerald Simpson trailing behind her. Steve shook my hand. That went better than expected. You did good. Thanks for handling this. What do I owe you? We've still got some of the retainer left. I'll send you a final invoice. Outside the courthouse, I took a deep breath of cold air. It was over. The snow pile was still on my property, still tall, and now completely legal. That evening, Alice called to congratulate me. The whole neighborhood's talking about it. Carol is furious, but a lot of us are happy someone finally stood up to her. I just wanted to pile my snow in peace. You did more than that. You showed that the HOA isn't untouchable. Over the next few weeks, the snow finally started to melt. My pile gradually shrank, and by early March, it was gone completely. But something else happened during that time. Other neighbors started questioning HOA decisions. When the board tried to fine someone for leaving their trash cans visible from the street, 3 residents immediately filed appeals. When Carol proposed a new rule requiring pre-approval for holiday decorations, it was voted down. The February board meeting, which had originally been scheduled to hear my appeal, turned into something else entirely. 15 residents showed up, including me. Alice was there, along with Tom and several others I'd only nodded to in passing. Carol tried to maintain control, but the mood was different now. People were asking questions, demanding transparency, requesting copies of the budget and meeting minutes. One guy named David formally announced he was running for a board position in the upcoming spring elections. Carol's authority was crumbling, and she knew it. She cut the meeting short, claiming she had another commitment, but everyone could see she was rattled. In late March, I got a visit from David. He was in his mid-30s, worked in tech, and had lived in Meadowbrook Heights for 5 years. "Patrick, a bunch of us are organizing a slate of candidates for the board elections. We want to reform how this HOA operates. Would you consider running?" "Me? I'm not really a political guy." "You don't have to be, you just have to care about fairness and property rights." "That's what this community needs." I thought about it. "Can I get back to you?" "Sure. But elections are in May. We need to decide soon." After he left, I stood in my driveway where the snow pile had been. The grass underneath was brown and matted, but it would recover when the weather warmed up. I thought about Carol Patterson, about the Henderson family who'd sold their house rather than keep fighting, about all the small injustices that happened when people with a little bit of power decided to abuse it. 2 days later, I called David. "I'll run." The campaign was informal, mostly just talking to neighbors and attending HOA meetings. Carol's faction tried to paint me as a troublemaker who'd cost the HOA money with unnecessary litigation, but that narrative didn't stick. Too many people had their own stories of HOA overreach, their own frustrations with arbitrary rules and selective enforcement. The elections were held on the first Tuesday in May. There were 5 board positions up for grabs. Carol was running for re-election as president. David was running for vice president. I was running for a general board seat, along with Alice and 2 others who shared our vision for reform. We swept the election. Carol lost by a 2-to-1 margin. When the results were announced at the May meeting, she sat in stony silence for a moment, then stood and walked out without a word. Jennifer Walsh, who'd come with Carol to my house before the court hearing, came up to me afterward. "I'm sorry about how things went down with the snow pile. Carol convinced us it was about community standards, but looking back, I think she just didn't like that you questioned her authority." "Water under the bridge," I said. "Or snow under the grass, I guess." Jennifer laughed. "Good luck with the board. I hope you guys can make this a better community." The new board's first action was to review and revise the HOA bylaws. We established clear procedures for rule changes, requiring not just proper notice, but also resident input periods before major changes took effect. We set limits on fine amounts and eliminated daily penalties for minor violations. We created an appeals process that didn't require going to court. We also established transparency measures. Meeting minutes would be posted online within 48 hours. Financial records would be available for resident review. Board members would have set term limits to prevent any one person from accumulating too much power. It wasn't revolutionary stuff, just common sense governance. But compared to how Carol had run things, it felt like a massive improvement. In June, I was in my front yard planting new grass where the snow pile had killed it. A car pulled up and I was surprised to see Gerald Simpson, the HOA's former attorney, get out. "Mr. Daniels, I hope you don't mind me stopping by." "Gerald, what can I do for you?" I wanted to apologize. I was just doing my job representing the HOA, but looking back, I should have advised Carol that her approach was unreasonable. Sometimes attorneys enable bad behavior when we should be counseling restraint. I stood up, brushing dirt off my knees. "I appreciate you saying that. For what it's worth, I think you and the new board are doing good things. I've represented a lot of HOAs over the years, and most of them would benefit from the kind of reforms you're implementing." Why don't they do it then? Inertia, fear of change. And sometimes, people like Carol who enjoy the power. HOAs can serve a legitimate purpose, protecting property values and maintaining common areas, but they need checks and balances just like any other organization. After he left, I finished planting the grass seed and watered it thoroughly. My neighbor Tom came over with a beer. Heard you're making waves on the board. Just trying to make things more reasonable. Well, for what it's worth, I'm glad you didn't back down over the snow thing. I thought about saying something at the time, but I was worried about becoming a target. I get it. Nobody wants to be in Carol's crosshairs. She gone for good, you think? I don't know. She still lives here, but I haven't seen her at any meetings. Tom took a sip of his beer. Property values are actually up, you know. Despite all her talk about how your snow pile was going to ruin the neighborhood. I laughed. Turns out people like living places where the HOA isn't constantly breathing down their necks. Summer came, and life in Meadowbrook Heights settled into a new normal. The board met monthly, handled routine maintenance issues, and stayed out of people's business unless there was a genuine problem. We didn't fine anyone for grass height or mailbox colors, or any of the petty violations that had been common under Carol's regime. In July, I ran into Carol at the grocery store. It was awkward, both of us reaching for the same type of coffee. She pulled her hand back first. "Patrick, Carol, how are you?" "Fine." She paused, looking like she wanted to say something else. Finally, she did. "I wasn't trying to be a villain, you know. I genuinely believed I was helping maintain the neighborhood standards." "I believe you. I just think you went about it the wrong way, maybe. Or maybe I just got used to being in charge and forgot that I was supposed to be serving the community, not ruling it. It was the closest thing to an apology I was going to get, and honestly, it was more than I expected. The neighborhood's doing fine, Carol. You don't have to worry about property values." She nodded and walked away with her cart. I wondered if she'd learned anything from the experience, or if she was just bitter about losing her position. Either way, it wasn't my problem anymore. The following winter, when the first big snowstorm hit in December, I cleared my driveway and piled the snow in the exact same spot as before. This time, it only reached about 5 feet at its peak, but I didn't care. Nobody sent me any letters. Nobody measured it or complained or threatened fines. It was just snow, doing what snow does, sitting on my property until it melted. David stopped by one evening after the storm. "Nice pile." "Thanks. I worked hard on it. I've been thinking. You should run for board president next term. I've only been on the board for 8 months. "Yeah, but you've got credibility. You're the guy who fought the HOA and won. People trust you." "I'll think about it," he grinned. "That's more than a no, I'll take it." After he left, I stood looking at my snow pile in the twilight. It seemed absurd that something so simple had caused such a massive conflict. But maybe it wasn't really about the snow. Maybe it was about the principle, about the right to use your own property without unreasonable interference, about standing up to petty tyranny even when it would be easier to just comply. A year after the original fine, almost to the day, I got a letter from the HOA. For a split second, my stomach clenched, old anxieties resurfacing. Then I opened it and saw it was just a notice about the annual meeting and budget approval. Routine stuff. Normal stuff. I tossed it on my kitchen counter and smiled. Sometimes the best victory isn't dramatic or cinematic. Sometimes it's just boring normalcy, the absence of conflict, the ability to live your life without someone measuring your snow pile and sending you threatening letters. The grass where the snow pile had been grew back thick and green. You couldn't tell there'd ever been anything there, but I knew. And every time I looked at that spot, I remembered the principle I'd fought for, the stand I'd taken, and the small but meaningful victory over bureaucratic overreach. The story of the snow pile became neighborhood legend. New residents moving in would hear about it from their neighbors, usually with a laugh and a shake of the head. Can you believe the old HOA tried to fine someone for a snow pile on their own property? It became shorthand for the bad old days, the time before the reforms, when the HOA was something to fear rather than just a boring administrative necessity. And whenever the board considered a new rule or policy, someone would inevitably ask, is this going to be another snow pile situation? It was a useful cautionary tale, a reminder to stay reasonable, to respect property rights, to govern with a light touch rather than an iron fist. And if a pile of frozen water could teach those lessons, then maybe it was worth all the hassle after all. In March, I ran into Jennifer Walsh at a neighborhood barbecue. She'd stayed on the board despite being associated with Carol's administration, and she'd actually become a valuable member, bringing institutional knowledge but supporting the new direction. "I never told you this," she said, "but I voted against that snow pile rule in the emergency meeting." "Really?" "But there were 3 votes for it." 2 votes. Carol and Mark Henderson. I abstained. Carol counted it as a yes because she said we needed unanimous consent for emergency measures. But that wasn't true. I didn't have the courage to fight her on it at the time. "Why are you telling me now?" "Because I want you to know that not everyone was on board with her tactics. Some of us just didn't know how to stop her. What you did, fighting back, it gave the rest of us permission to speak up." I appreciated her honesty. It was a good reminder that organizations aren't monolithic. Even in Carol's HOA, there were people who disagreed but felt powerless to act. Change often starts with one person willing to take a risk, and then others find their courage. The annual meeting in April was well attended. We presented the financials, which showed the HOA in good shape, despite Carol's warnings that our reforms would lead to chaos and declining property values. In fact, we'd saved money by reducing legal fees and eliminating the petty enforcement that had wasted everyone's time. During the open comment period, an elderly man named Frank stood up. "I've lived in Meadowbrook Heights since it was built, 20 years ago. This past year has been the best year of HOA governance we've ever had. I want to thank the new board for remembering that you work for us, not the other way around." There was applause, not thunderous but genuine. It felt good. After the meeting, as people were leaving, a young couple approached me. They were new to the neighborhood, had just bought the Hendersons' old house. "We heard the story about the snow pile," the woman said. "We almost didn't buy in an HOA because of horror stories we'd heard. But when we learned about the reforms here, it convinced us this was a good community." "Glad to hear it," I said. "Welcome to the neighborhood. We actually have a question. We want to put up a fence in our backyard. Is that going to be a problem?" "As long as it meets the height restrictions and isn't right on the property line, no problem. Just submit the request form on the website. We'll approve it within a week." They looked relieved. "That's it? No 3-month approval process?" "That's it. We figure if it's on your property and not bothering anyone, why make it complicated?" They thanked me and left, and I realized that this was what HOA governance should be. Not complicated, not adversarial, just neighbors helping each other maintain a nice community while respecting individual rights. In May, I did end up running for board president. It felt strange, going from the guy who fought the HOA to the guy leading it. But David was right that I had credibility. People knew I wouldn't abuse the position because I'd experienced that abuse firsthand. I won easily. At my first meeting as president, I laid out my vision. We're here to serve the community, not control it. We maintain common areas. We enforce reasonable rules that protect everyone's property values, and we stay out of people's business otherwise. If we're doing our jobs right, most residents should barely notice we exist. It wasn't a revolutionary speech, but it set the tone. And over the following months, we stuck to that principle. We handled genuine issues, stopped painting between the lines of arbitrary rules, and treated residents like adults capable of managing their own properties. Carol moved away in August. I heard from Alice that she'd bought a condo in Denver, something without an HOA. There was some irony in that. Maybe she'd learned something after all, or maybe she was just tired of facing the neighbors who'd voted her out. Either way, I wished her well. She'd been wrong in how she handled things, but I didn't think she was a bad person, just someone who'd gotten too caught up in the power and lost perspective. The next winter, when snow fell, my pile was modest. Not because I was worried about complaints, but because I'd figured out a better system for distributing the snow across my property. I'd learned some things too, but on principle, I made sure part of the pile still reached a respectable height, at least 5 feet, just as a reminder. Just to make the point that it was my property, that no HOA board was going to tell me how to pile my snow. Tom noticed one morning when we were both heading to work. "Still flying that flag, huh? Someone's got to." He laughed and got in his car. I did the same, scraping frost off my windshield and thinking about how strange life could be. A year and a half ago, I'd been embroiled in a legal battle over frozen precipitation. Now, I was president of the same HOA that had tried to fine me. The whole thing seemed like something that couldn't really happen, except it had, and I had the court documents to prove it. The engineer part of the story came later, in a way I didn't expect. In February, almost 2 years after the original conflict, a new family moved in next door to where Carol had lived. They were doing some property improvements and hired a civil engineer to survey their land for a retaining wall project. The engineer, a guy named Robert Chen, knocked on my door one afternoon. "Mr. Daniels, I'm working on the Patterson property next door, and I noticed something interesting while reviewing the plat maps." "What's that?" The original survey markers were off by about 3 feet. "It doesn't affect the current owners, but it means the property lines weren't where everyone thought they were, including for your lot." "How so?" "That area where you had your snow pile 2 years ago. According to the corrected survey, it's actually about 6 feet from the property line, not 3. You had even more clearance than you thought." I had to laugh. "So Carol was even more wrong than we proved in court." "I heard about that case. It's actually cited now in HOA training seminars as an example of what not to do." "You're kidding." "Nope. I consult for several HOA management companies. Your case, along with a few others, has become part of the curriculum for teaching board members about proper procedures and respecting property rights." "Huh, I guess that's something." Robert provided me with a copy of the corrected survey, certified and official. I filed it with my property records. One more piece of documentation proving that the snow pile had been completely legal, completely on my property, and completely none of the HOA's business. I showed Steve Richardson the survey when we met for coffee a few weeks later. He'd become a friend through the whole ordeal, and we still got together occasionally. "This is perfect," he said, reviewing the engineer's report. "If Carol had pursued the case further, this would have destroyed any remaining argument she had." "Think she knew the surveys were wrong?" "No. I think she just didn't care about the details. She decided you were violating her sense of community standards, and she went after you without doing proper due diligence. It's a common problem with HOA boards. They forget they need to operate within the law, not above it." "Well, we're trying to do better now." "I know. I've recommended Meadowbrook Heights to several clients looking to buy in the area. When an HOA attorney says good things about an HOA, that's high praise." In March, the community held its annual spring cleanup day. Residents came out to spruce up common areas, plant flowers, and generally make the neighborhood look nice. It was voluntary, no fines or penalties for not participating, but dozens of people showed up anyway. I was planting tulip bulbs along the main entrance when Alice came over. She was moving slower these days, but still sharp as ever. "You've done well, Patrick. This feels like a real community now, not a dictatorship. We all did it together. Don't be modest. You took the risk when it mattered. The rest of us followed your lead." That evening, after the cleanup, several of us gathered at Tom's house for a barbecue. Kids played in the yards. Adults stood around drinking beer and talking about normal things like sports and work and the weather. Nobody mentioned HOA rules or violations or fines. It was exactly what a neighborhood should be, and for the first time since moving to Meadowbrook Heights, I felt like I was truly home, not just in a house, but in a community. And maybe that was the real lesson of the snow pile saga. Communities aren't built through rules and enforcement. They're built through respect, through treating each other like reasonable people, through solving problems together rather than imposing solutions from above. The snow pile was long gone, melted into nothing over a year ago. But what it represented remained. It stood as a reminder that property rights matter, that procedural fairness isn't optional, and that citizens have both the right and the responsibility to push back against overreach, even when it's easier to comply. And if I ever doubted whether it had been worth the hassle, I just had to look around at the community we'd built. A community where people could pile their snow in peace, where the HOA served rather than ruled, where neighbors actually liked each other instead of living in fear of the next violation notice. Sometimes the smallest things lead to the biggest changes. A pile of snow, 7 feet tall, sitting on private property in a Colorado winter. It shouldn't have mattered, but it did. And I was glad I'd fought for it, glad I'd stood my ground, glad I'd helped transform an oppressive HOA into something that actually served its community. The grass grew green where the snow had been. The neighborhood thrived under reasonable governance. And every winter when the first snow fell, I smiled and piled it exactly where I wanted it, exactly as tall as I needed it, on my own property, exercising my rights as a homeowner and an American. That was the real victory. Not the court ruling, not becoming board president, not the reforms we implemented. The real victory was the freedom to live my life without unreasonable interference, to use my property as I saw fit within reasonable bounds, to be treated like an adult rather than a subject, and I'd fight for that victory again if I had to. But hopefully, I wouldn't have to. Because the lesson had been learned, the precedent had been set, and the community now understood that power comes with responsibility, authority requires accountability, and sometimes a snow pile is just a snow pile, nothing more, nothing less, and definitely not worth a $250 fine.